Order, order. Would everyone please ensure that all electronic devices are turned off or switched to silent mode? And we will now continue line by line consideration of the bill. The grouping and selection list for today's sitting is available in the room as well as on the parliamentary website. I remind members about the rules on declaration of interests as set out in the Code of Conduct. We adjourn the debate on the question that Clause 5 stands part of the bill. Matt Vickers.
Thank you. Pleasure to serve you under your first outing. Clause 5, subsection 3 requires those who are cooperating with the Commander in their exercise of their functions to put in place arrangements governing cooperation between the Commander and that person. Does the Minister have a view about what these agreements will look like and what sort of obligations will fall on both parties?
Thank you very much, Mr. Stewart, and it's a pleasure to serve under your chairmanship, the first of many, I'm sure, and I hope that you enjoy chairing bills as much as I enjoyed chairing them in the last Parliament. Clause 5 places a duty on partner authorities to cooperate with the Commander in the carrying out of their functions. The Commander is tasked with maximising the effectiveness of our collective response to border security threats, which requires a whole-of-government response and will be enabled by this clause. It's recognised that partner authorities have wide-ranging functions that extend well beyond tackling border security threats. The duty set out in this clause extends only so far as it's appropriate and compatible with partner authorities' other functions. This ensures that partner authorities across the system are working in lockstep to enhance border security whilst continuing to enable their vital work undertaken by partners in other contexts beyond border security matters.
The question is that Clause 5 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that Clause 6 stand part of the bill. Minister?
Thank you, Mr. Stewart. Clause 6 places a duty on the Border Security Commander to establish and maintain a board to assist with the exercise of their functions. This unique forum enables senior representatives from across the border security system to convene to shape our collective response to organised immigration crime and other border security threats. The Commander will consult the board when developing strategic priorities for border security, which makes the board a crucial forum in shaping the whole of government response to these threats. I move the clause stand part of the bill.
Clause 6 specifies the Border Security Commander must establish a board to assist the Commander in the exercise of the Commander's functions. This is all quite open-ended. The Chair will be the Commander and the board made up of one or more representatives from each relevant partner authority. Can the Minister explain on what basis the Commander might decide to have representatives from partner authorities? Given that all partner authorities do not need to be represented, why do all partner authorities not need to be represented? Subsection 6 states that the Commander must hold meetings at intervals that the Commander deems appropriate. Does the Minister have any views about how regular these meetings should be? And what sort of matters does the Minister envisage the board will be dealing with?
Well, I think, Mr. Stewart, that what we have in the bill is a framework within which the Border Security Commander operates, but which isn't prescriptive, as if the people who drafted the bill could see what the priorities will be in the future. And so what we have in the legislation is a framework which enables the Border Security Commander to respond to what's going on at the time without it actually limiting him. And I think there's been a common theme throughout some of the discussion that the opposition, from the opposition, that they feel somehow the Commander doesn't have sufficient empowerment to command the border security system. He isn't independent enough, that somehow he can't get things done. But the functions outlined in these clauses aren't the sole capabilities of the Commander's role as empowered by the Home Secretary and also the Prime Minister. The Border Security Command is not an operational entity. It's a strategic leader for the border security. So, for example, representatives on the board would be government departments like the FCDO, HMRC, Department of Transport, DEFRA, Cabinet Office, also operational partners such as the NCA, UKIP, the Security Services, Border Force, Immigration Enforcement, Policing, those kinds of people to be convened in for a strategic purpose. And it makes sense, if you think about it, Mr. Stewart, that the commander can bring these people together as and when he or she sees a need for them to meet, depending on what's on the agenda and what's going on. The commander is already using the role and its associated capabilities to deploy key functions to lead on border security across government, including deploying additional resources across partners, such as the additional £150 million for border security, which has been announced by the government, developing legislation for border security to be used by operational partners, such as the powers in this bill. And we heard last week during the evidence sessions about the views from operational partners such as the police and the NCA and the CPS about how useful they felt that some of the powers in this bill would be to their everyday operational capacity. Also, the operational commander can lead on international engagement diplomatically and has certainly accompanied both the Prime Minister and the Home Secretary on some of their journeys to Italy, to Germany, to Iraq. I think to ensure that we have meetings at the highest levels with people in other jurisdictions to try to get more cooperation going to deal with the cross-border issues of border security. So the bill provides a new significant wide-ranging power to lead the border security system strategically, which is something that's been done for the first time. All partner authorities, defined as those public bodies with function in relation to border security, must, as a legal duty, have regard to the strategic direction set by the commander. But this works best if there isn't a battle between different bits of the government. It works best if there's cooperation, coordination, and that is what these structures, Mr. Stewart, are designed to try to achieve. So this will for the first time provide a clear and long-term vision for border security, bringing together and providing leadership to all parts of the system that work to maintain the integrity of both our border and immigration systems, domestically and internationally. So I hope that that might explain a little bit more to the opposition the thinking and approach behind some of the powers that they see in the clauses that we're considering at the moment, obviously most specifically Clause 6.
The question is that Clause 6 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to the question that Clause 7 stand part of the bill. Minister.
Thank you again, Mr. Stewart. Clause 7 ensures that the functions of the Border Security Commander can be delegated to an authorised civil servant when required. Flexibility in the exercise of these functions will support the most efficient and effective delivery of the government's actions to tackle border security threats.
Vickers.
Clause 7 makes provision about the delegation of the commander's functions. Subsection 1 provides that the functions conferred on the commander by this chapter may be exercised by any civil servant authorised by the commander for that purpose. This is further evidence, were any needed, that the post of commander might not be a serious one. We've already seen that the bill does not specify any minimum qualifications or experience of the commander, and we've seen why, as the commander is not really in charge of anything. But there are serious questions to answer about the delegation of functions. What sort of functions does the Minister envisage that the commander might delegate under this clause? Can any specific functions be named? The bill does not specify any level of seniority for those the commander might delegate functions to. Is there any grade within Home Office that the Minister thinks it would not be appropriate for the commander to delegate to, And what oversight will there be of any delegation process?
Thank you, Minister.
Thank you once more, Mr. Stewart. I think I've just set out in some detail in my reply to the debate on the previous clause some of the things that the Commander is involved in doing, some of the meetings he's involved in convening, and some of the purpose for which those strategic meetings are had. I think also when we listened to some of the evidence that we had from the operational partners last week during the first evidence gathering sessions of the bill, both the NCA and the police chiefs set out some of the benefits that they felt. Oh well, yeah.
Thank you. Thank you. Sorry, Mr. Stewart. Thank you, and it's an honour to be here. Is it all right if I speak? Yeah, sorry. Yeah. I just wanted to, sorry, I'm not sitting or standing, sorry. I just wanted to raise, I don't know if the Minister would agree, that we kind of seem to be having repetition in regards to the Commander and his ability within that role that he has, which he is respected, that come up from the previous evidence as well. Do we just feel that there's kind of repetition with that, where the opposition just kind of picks it at every moment? Thank you.
Thank you, Mr. Stewart. I think that the opposition have asked at what level and which bits of the Commander's function might be delegated. Well, in theory, it's to enable that to happen, so there are no issues in law or in primary legislation which would prevent something being delegated that was effective. But I don't think that the Honourable Member for Stockton West would expect me to go into great detail about what might happen in the future with the delegation. If one assumes, for example, that there was a high-level visit to, for example, Iraq, in order to try to conclude a memorandum of understanding on returns and activity against organised immigration crime, the Commander was detained elsewhere, then it would be possible to delegate a function such as that to somebody who will go in his place. So it's really to get to the stage where in legislation we create the Commander, but also give flexibility to how that job can be put into effect in potential scenarios that may crop up without being too prescriptive. And I hope that the Honourable Gentleman will I hope the Honourable Gentleman will take that as a sort of example that may crop up.
Chris Murray.
I thank the Minister for giving way, and it's a pleasure to serve under your chairmanship, Chair. It's quite interesting hearing the points that the Minister's making there when we consider the conversation that we had earlier this morning about the Commander being functionally a civil service employee and a civil servant. And from my experience, although I was never officially a civil servant in the proper sense, it's really important that senior leaders within the civil service are able to avail themselves of the delegation capacities that they need. That can be for many reasons. It could be a bandwidth issue where someone has multiple priorities and they need to delegate to someone else because they aren't able to be in two places at once. And when you look at the responsibilities of the Commander that are set out in legislation, there's a lot there. It could also be a resourcing issue. And it could also be because of a conflict of interest. And that brings me to the point I was making, apologies, about this being a civil service role. You need to have proper conflict of interest, and that's what we're taking account of here.
Well, my honourable friend is right that often there are circumstances that crop up that require this kind of thing, and all Clause 7 does is allow it. I move.
The question is that Clause 7 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. We now come to the question that Clause 8 stand part of the bill. Minister.
Thank you, Mr. Stewart. Clause 8 ensures that the functions of the Board Security Commander can continue to be exercised in the event that the post of Commander is vacant for a period of time, or if the Commander is incapacitated or temporarily unavailable. This ensures that the work to enhance our border security and undermine the people smuggling gangs who are threatening our borders continues in the event that the post either falls vacant or is effectively vacant for a period of time.
Matt Vickers.
Clause 8 allows for an interim border security commander to be designated. Would be great if the Minister could confirm that this is essentially a stopgap, either because a border security commander is going to step down without a replacement, or for reasons of temporary incapacity to carry out the function. Subsection 2 specifies that the interim border security commander can be designated for such a period as the Secretary of State thinks appropriate. I'd like the Minister to explain whether there is a limit to what could be regarded as appropriate. This is on the face of it a temporary measure, so what counts as temporary for these purposes? What are the safeguards against an interim appointment carrying on indefinitely? Subsection 3 says that the temporary designation can last no longer than the period for which no commander is designated, or as the case may be, the commander is incapacitated or unavailable, but there isn't a time limit set out in the bill. Are there any minimum qualifications the Minister would expect an interim commander to have?
Well,
Minister.
Mr. Stewart, yes, I mean it's clearly the case that Clause 8 is there in the event of the commander being incapacitated or ill and unable to do the job for a while. It's not unusual that people have life experiences which mean they have to take time off work, and in that kind of instance an interim commander could be appointed pending the return of the role holder because they were receiving medical treatment or were incapacitated in some way. There may also be a gap between the resignation of a commander or a retirement and reappointment, although one would hope that planning ahead would mean that that would be minimised. So this is just a practical issue in terms of having an interim in case there were an issue with appointing. The interim commander would obviously be expected to have the skills to do the job to the full extent. There isn't a time limit put into primary legislation because again doing so would sort of make it harder in practical terms to perhaps get a replacement if there was a hard timeline. So it's really very much a horses for courses thing, which allows there to be an interim in the case of incapacity, retirement or replacement, whilst the replacement is advertised for and appointed in the usual manner.
The question is that Clause 8 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. Clause 9 was debated with Clause 3. The question is that Clause 9 stand part of the bill. As many of that opinion say aye.
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 On the contrary, no. I think the ayes have it. We now come to the question that Clause 10 stand part of the bill, with which it will be convenient to consider Clauses 11 and 12 stand part. Minister.
Thank you very much, Mr. Stewart. This grouping of clauses contains Clause 10, which states that the duties in this chapter don't apply to the armed forces, Clause 11, which makes amendments to the Data Protection Act, and Clause 12, which provides definitions of the terms used. The work of the armed forces and the Ministry of Defence makes a significant contribution to the security of the United Kingdom. The Border Security Command will work across government, including with the Ministry of Defence, to enhance our border security. Clause 10 recognises the unique work of the armed forces, while the Border Security Command will work closely with the armed forces, including through the Ministry Aid to the Civil Authorities process. It is correct that the important duty of our armed forces remains independent from the functions outlined in this chapter. This is achieved by Clause 10. Clause 11 amends the Data Protection Act to ensure the Border Security Commander may process data for law enforcement purposes. This information is vital to build a shared understanding of the nature of the border security threats and to inform the priority setting process. Finally, Clause 12 provides definitions of the terms used in Chapter 1 of the Bill for the reader's understanding and to ensure clarity on definitions during the implementation and operation of the legislation.
Vickers.
Clause 10 makes it clear that this chapter does not apply to the naval, military or air forces of the Crown. Clause 11 is an amendment to the Data Protection Act 2018 to allow the Border Security Commander to be added to the list of competent authorities in relation to the processing of personal data carried out for a law enforcement purpose. Given how toothless the Border Security Commander appears to be, can the Minister explain why this post needs to be added to Schedule 7 of the Data Protection Act? What law enforcement purposes will the Commander have, and for what purpose are they going to be processing personal data?
Minister.
Thank you very much, Mr. Stewart. The member for Stockton West, I will learn all these things by the end of the bill, has asked why the Border Security Commander should be processing data collected from electronic devices. He will know that later on in the bill there are some new powers which involve collecting in an intelligence-led way data from suspected organised immigration criminals. And the point of this clause is to ensure that data is collected in a lawful manner. And so that's why clause 11 allows for the Border Security Commander to process data for law enforcement purposes. And some of this is about the counter-terrorism style powers, which we will come on to discuss in later sections of the bill. So I don't want to have that debate here, Mr. Stewart, but it's really an enabling power in order to put beyond doubt the legality of collection of this kind of material.
The question is that Clause 10 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. Clauses 11 and 12 have just been debated. With the leave of the committee, I will put a single question on those clauses. The question is that clauses 11 and 12 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 3 to Clause 13, with which it will be convenient to debate Clause 13 stand part, Amendment 4 to Clause 14, and Clauses 14 and 15 stand part. I call Pete Wishart to move Amendment 3.
And thank you ever so much, Mr. Stewart. It is an absolute pleasure to serve under your chairing this afternoon, and I welcome you to this committee. Well, clauses 13 to 18 is where we start to get into the serious business about this bill, where some of the most concerning and controversial aspects of this bill are revealed, and nowhere is that more certain than in clauses 13 and 14. Now, throughout this bill, this is the government that tells us that the whole intention and focus is exclusively on smashing the gang, disrupting their business and bringing as many of these people associated and involved in this vile trade to justice. And everything that we do in this committee, everything we do in this House, I think the whole community must ensure that the government is supported in that ambition and intention. There's the one thing that unites all of this House, and we wish this government every success in disrupting these gangs, smashing their business operation and bringing them to justice. Now, if you look at clauses 13 and 14, the first thing you've got to do is assess and make a judgment about whether what's included in these clauses aid and assist in that business and process. And I think we have to come to this conclusion that they don't. What they could actually do is make the situation a lot worse. It will certainly make the situation conditions of those who are seeking to come to our shores, some of the most wretched people in the world, much more harder and much more intolerable. I'll give way to them.
Thank you so much, Mr. Stewart. Does the member hold the view that an asylum seeker cannot be above the law when it comes to participating in smuggling gangs?
Absolutely not. I don't think anybody would try and assert intent or propose that. Everybody is subject to the laws. What we are doing with clauses 13 and 14 is ensuring new criminality, new laws, which has within their focus and their ambit, I believe, because I listened carefully to the government's rhetoric, to smash the gangs, to make sure their business is disrupted. But they're not going to do that. The only people that they are going to ensnare and entrap and be on the wrong side are asylum seekers. So what we're actually doing, we'll say candidly to the Honourable Lady, we're inventing, creating new ways to further criminalise the most wretched people in the world. And that is quite clearly a grotesque ambition for this government to lay forward. I tried to find out, Mr. Stewart, from the senior law officers that we had at our evidence session, how many members of gangs would be apprehended and brought to justice by these new clauses. They couldn't tell me. I don't blame them for that. They probably didn't know. I would suspect they would have a really difficult case to try and even make some sort of guess about how many they would bring to justice. I also asked them, what proportion of ordinary asylum seekers would there be to gang members, those that actually secure this foul trade? They couldn't tell me. But I know, and I suspect, and I'm sure they know and they suspect, that nearly everybody who will fall foul of these two new clauses will be asylum seekers. And I suspect they know, as I know, and probably everybody else knows, there will be very little members of gangs that will be brought in front of any of our jurisdictions because of what's included in these new clauses.
I thank the member for giving way. Thank you, Chair. There's an issue around taxonomy here, around categorisation. Anyone is entitled to claim asylum. It is a universal human right. Anyone from any nationality, of any background, whatever their criminal history, is entitled to make the claim to an asylum seeker. You can be a member of a criminal gang and plan on claiming asylum. And from my 15 years of working in the Asylum and Immigration Service, it is an undeniable point of fact that some people exploit that in order to delay or get round the system. And we do quite probably have to take their views forward. So would the Honourable Member agree with me that we've got to be careful in our classifications here, because actually there's a distinction between an asylum seeker with a genuine claim to refugee status, an asylum seeker who with a genuine claim but who will not be eligible, and someone exploiting the system?
Before you reply, Mr. Worship, that was far too long, Mr. Barry, so please try and keep interventions short, and of course everyone is welcome to speak in the debate.
That's a reasonable point by the Honourable Gentleman, and I think he's actually onto something. Of course, there will be some gang members pretending to be asylum seekers, but that's up to these very fine people that came in front of our committee the other day to try and determine and trying to ascertain, and that's what they're doing. What we don't do is make further criminalised causes which are going to almost exclusively focus on these asylum seekers. We find ways to disassociate that. We don't just have blanket, broad defined clauses which will include everybody in our proceedings. So, and I know the Honourable Gentleman has a fine history and record working with asylum seekers and refugees. But he'll know, because he'll have seen the briefings as I have, as everybody else in this committee has done, practically every charity, organisation, those charged with working with asylum seekers and refugees tell us, and those that are working to improve their lives, the situation, tell us it will be ordinary asylum seekers fleeing conflict, oppression and extreme poverty that will be caught up in these new measures. So my amendments, Mr. Stewart, are very, very straightforward. Let's remove asylum seekers from the provisions of clauses 13 and 14. Now, I want to do this for a number of reasons, but one of the ones that I think the Minister might be most attracted to, is that this will actually help the Border Commander and Border Command, because removing asylum seekers from these clauses will allow him to exclusively focus laser-like on the main issue, the main target for all of this bill, for all of these new measures, the gangs, those that ply in this evil trade. Let's forget about the riffraff and the chaff. Go for them. Let's make sure that all of our attention is focused on those that arrange, organise this vile trade across the Channel, and let's make sure that we go for them.
Would the Honourable Member give way?
Yes, of course.
I thank the Honourable Member for giving way. Would he agree with oral testimony that was given last Thursday, and I quote from Rob Jones, who's the Director General of Operations at the National Crime Agency, "We are not looking to pursue asylum seekers who are not involved in serious and organised crime. That is not what we do. This is about tackling serious and organised crime and being as effective as we can in doing that." I want to posit that because some of what you're saying, if you were to read the tea leaves, it's almost as if you're saying that there might be an intent to pursue asylum. I apologise, Chair. It could be that you are that he is implying that there's an intent to pursue asylum seekers, but moreover, it's the National Crime Agency's remit to specifically go after those organised gangs and to be laser focused already, as he's recommending.
It's a feature of this committee, Mr Stewart, that there are rather lengthy interventions, but I'm happy to go with that if the rest of the committee is. But he's right, and he's right to reference the Border Command. No, it wasn't the Border, the National Crime Agency, Mr Jones. And I listened very, very carefully to what he had to say to this committee. And I've no doubt that's his intention. I don't think he really wants to ensnare asylum seekers. I don't think that is his focus either. But what he's got with these two badly drafted, broadly defined clauses is the net that will scoop it all up. And it's like the Honourable Gentleman from Edinburgh, he says, everybody will be in that net, and it's going to be a matter of trying to cipher. So why not start with the presumption that we go for the gangs exclusively, and we leave these people who are coming to our shores to legitimately apply for asylum in the United Kingdom. Leave them aside and to focus on these guys. And if we're in our business of going for them, let's not waste time criminalising these people who are coming to the shore. Now, the main problem, as I've said already, is that these clauses are just so broad in scope. It's not just a fishing net, this is a trawling net that's trying to lift out everybody who's coming across the Channel. And they're just covering not only direct acts of people smuggling, but also incidental activities that may not have any criminal intent. Now, combined with other clauses, it would become a crime to supply or receive almost any item that one suspects could be used to facilitate illegal travel to the UK. The law criminalises collecting or even viewing information that could be useful in making irregular journeys if there is reasonable suspicion it could assist others in migration. And while the government couches a lot of this in humanitarian language, these provisions will not prevent deaths and harms at sea. Instead, what it will do is to criminalise people on the move who have no alternative route to the UK. So let's just look at some of these clauses in just a little bit more detail. The supplying, offering to supply and handling articles for use in immigration crime will now get you a maximum sentence of 14 years imprisonment. And while there are some limited humanitarian exemptions, for example, offering food and drink, these clauses considerably broaden the potential prosecution of migrant assistance and support. Importantly, with all of these new proposed offences, there appears to be no explicit defence legislated for those on the move themselves. Then there's this, collecting information for use in immigration crime. Such information includes arranging departure points, dates and times, or in other words, information that would be necessary to gather if you were attempting to make such a journey yourself. This bill makes it clear that evidence could include someone's internet history and downloads. Now, it's contested, and I heard it contested with the government, that even looking up a weather map could bring you on the foul side and the wrong side of the new clauses. And I respect the government telling me, no, of course that won't happen. But there's nowhere, when you look at these new clauses, that that particular activity is exempt. So, yes, of course.
I thank the Honourable Member for being willing. Thank you, Chair. It's a privilege to serve under your chairship. I asked the Honourable Member whether he felt the representations made, particularly by the CPS at our evidence gathering session last week, gave that assurance when the witness that we had before us categorically stated that the circumstances which he references would not pass the criminal nor the public interest test to be used in that way. And does he think it's really important when we are discussing the bill that we make sure we are not making those inferences so we can see clearly how those things would be applied by our criminal justice system?
A helpful and useful intervention, and she's right. They did say that, and I listened again very carefully to what they did say, because this is an issue that's been raised repeatedly about the concern about some of these new clauses. And I'm sure they're serious about that. But I challenge the Honourable Lady to look at the clauses, to look at the subsection, and tell me how such a scenario couldn't be caught in this. And I think this is why this bill is badly drafted. It allows the perception and the conditions for something to do. And I know they don't want to arrest people who are looking at weather maps, and I'm certain that's not their intention at all. But this bill, when examined and looked at, will allow that very thing to happen. Now, I think what she's referring to is the Section 25 provisions which are in the Legal Immigration Act of 1970 or 72. I see the Minister nod her head. 71. There we go. We've got there, which again allows for a reasonable explanation and definition about why people are caught up in such activity. And that is the protection that is offered here. The Section 25, the legislation, is something that is useful when it comes to this. But why are we having to rely on something like this? We're creating a new bill here which does a specific thing which is not helpful for some of the poorest, most wretched people that exist in our globe, who we have a responsibility for under international obligations and conventions, and we're not doing anything to assist them by what we're doing with these new pieces of legislation. The collection of data from people's phones is facilitated by the new book, which creates new broad powers to enable the search and seizure of electronic devices. Now, I want to come back to my main point that I made in the second reading. I know we didn't get much time to elaborate on these points, but I think this is really pertinent to these clauses, and I think the committee has to consider this absolutely properly. These gangs have a monopoly and an exclusive right to the irregular migration market. There's no other way for asylum seekers to get to the UK other than to use these gangs. It just isn't possible. I know there's safe routes available for certain small amount of countries, but for the vast majority of potential asylum seekers in war-torn regions, areas and countries around the world, the only way they can claim their asylum in the United Kingdom is to put themselves at the mercy of these gangs and go on a small boat to get across the channel. And business is booming, isn't it? Business, I don't know if anybody saw the shots today, I think it was on Sky News, from the camps in France. What a hell on earth that is, and what a disgrace that is for us who are part of this whole problem, who cannot get this situation resolved, and we're keeping some of the poorest people in situations and conditions such as this. Shame on us, and shame on everybody in the international community who allow such conditions to develop and to thrive. Business is booming for these illegal gangs. And I'll tell you something else, Mr. Stewart. It's only going to get better for them when that lot cut the international aid budgets. What do you think is going to happen? Do you think conditions are going to get better in these areas? Of course they're not. It's going to lead to so many more people making this journey to the UK, and that will be down to them. And I will hope the honourable gentleman's got some sort of reason for that.
Thank you. I have an important intervention on that, the Russians invading Ukraine and going further into Europe would create a much more serious refugee crisis than the one we are facing now. So increasing defence spending is very important.
I don't know if the Honourable Gentleman's noticed, but for the last 3 years we have had a refugee crisis from Ukraine. And this is one of the things, such a distinction about how we responded to Ukraine and how we've responded to everybody else. We put forward legal routes to allow these people to come to our country. My local authority area, Perth and Kinross, is the largest number of asylum seekers, refugees from Ukraine, other than the city of Edinburgh, in the whole of Scotland. And I am immensely proud of the generosity, of the spirit of the people I represent for taking part in that scheme. But isn't it so different to when we allow schemes like this? This is what we're asking for. This is what we're saying to the Minister. We will have a depopulation crisis towards the middle part of the century. Immigrants might be a premium by 2060, 2070. Why aren't we being inventive? Why aren't we being creative? Why aren't we looking to do things other than leave that mess, that disgrace on the shores of France as we have done today? Now, I'm sure the Minister will tell us that will be this defence of reasonable excuse, and I accept that. I know that's in the provisions of the bill, which applies to each of these new offences. In other words, if a person has a reasonable excuse for engaging in the relevant conduct, they will not be guilty of the offence. And I know that's what she's going to speak back at me. She's already indicating that's exactly what it's going to be. But the burden lies on the defence to adduce sufficient evidence of a reasonable excuse, such that it's placed on an issue. If they have done so, it is for the prosecution to prove beyond reasonable doubt. And again, to be fair, the bill sets out a non-exhaustive list of circumstances in which the defence of reasonable excuse will apply. Under Section 13, for example, a person will have a reasonable excuse if their action was for the purpose of carrying out a rescue of a person from danger or serious harm. They will also have a reasonable excuse if they were acting on behalf of an organisation which aims to assist asylum seekers and does not charge for its services. But all of this, Mr. Stewart, is purely judgmental, and there does not seem to be a specific threshold for conviction. And the maximum sentences for each of these new offences are pretty stiff. The maximum sentence for the Section 13 and 14 offences in particular are disproportionately high. To put this in context, if the offence of possession of articles used in terrorism has a maximum of 15 years, you could get 14 years for being foul of these particular clauses. So broad strokes of the bill is likely to have an impact on the prison population. I think I heard the Honourable Member for Stockton address some of the issues about the prison population with the Minister in the sections about... Yes, of course.
Thank you. Thank you, Chair. It's a pleasure to serve with your chairpersonship, and I would have said that earlier. So apologies. Can I just clarify, is the Honourable Member saying that the proposed sentence for the facilitation of small boat smuggling and criminal activity is too high? Did I hear that correctly, or am I wrong? Please do correct me if I'm wrong.
The General is wrong, and they didn't hear me correctly. It's the provisions within these new clauses for the new offences, which could reach up to a maximum of 14 years imprisonment for falling foul of the new clauses 14 and 15. Now, he might contend that that might actually get some gang member. I am suggesting otherwise, that I don't suspect there will be practically anybody who will be caught up from gangs who are involved in this illegal trade, this vile trade, who will be caught up in these offences. It will be ordinary asylum seekers. And just lastly, on some of the prison population issues, there's a notable lack of robust evidence that lengthier custodial sentence achieve a deterrent effect or a reduction in reoffending. Again, looking at the bill, this is explicitly not acknowledged within the impact assessment of the bill itself when it says there is limited understanding of the behavioural impact of this intervention, so the deterrence effect on dangerous behaviour may not be realised as intended. Now, that's within the notes of the bill itself. I don't know if the Minister really believes that this legislation and the new law she's creating is going to make the slightest bit of difference to those currently in areas of conflict or fleeing oppression. I'm not entirely sure that asylum seekers sitting on the beach, sitting in the deserts of Sudan or in Afghanistan or in Iran have the least bit cognizance of the developing, hardening, draconian laws of this country that has been put in place in committees like this. I would suspect they don't know about it, and if they did know about it, they would not care less. Their sole and exclusive priority is saving their family, their children's life, and getting the hell out of that place. That is their intention. They could not care less about the Borders, Asylum and Immigration Act that's debating here today. They want out, and they will do anything possible to rescue their family. Imagine that, after all that journey, to sit in these boats, to be at the hands of the people smugglers and those gang members. They arrive in the good old United Kingdom to be apprehended on the basis of Clause 13 and Clause 14 of this bill. We heard from a variety of witnesses on Thursday that the laws of the destination country make absolutely no difference whatsoever to asylum seekers, and it does not work in the least as a deterrent. So I don't want to hear about the deterrence from honourable members opposite, because there is no evidence to suggest that that works or supports that contention. So come on, let's take these wretched souls out of the equation, remove them from the legislation, go for the gangs that profit by this vile trade, and make sure that we have a bill that we can be proud of, that we know what it's going to do, and will not entrap lots and lots of innocent people. I beg to move.
Amendment 3 proposed clause 13 as on Amendment 8. The question is that the amendment be made. I call Mike Tapp.
Thank you, Chair, Mr Stewart. Thank you for your passionate speech. It gripped us all, I'm sure. Here's my apology. We'll not make that mistake again. Look, it's really important that we look at the what this covers in the bill and how it enables our Border Security Command, National Crime Agency, the police, the Border Force, the security services to act. We said before the election in the manifesto that we were going to take this on in a counter-terror style so that we can get to those who are looking to launch the boats before they launch them. And these clauses go some way to achieving that, and I won't quote the NCA DG again, but he was very enthusiastic about that. Of course, with the further clauses, it includes these acts taking place abroad and not just in the United Kingdom. On the specific amendments, we've got to be clear. We don't know who is a genuine asylum seeker at the point that they seek to cross chair. We won't know for some time. And the elephant in the room here is even if they are genuine asylum seekers, they're in France, they're not in danger like they would be in Sudan, and by putting others at risk by preparing these crossings or having any facilitation involvement is not acceptable. If you're an asylum seeker, it does not make you above the law, and these clauses ensure that they'll be held to account.
Thank you, Mr Stewart. As honourable members will have read, Clause 13 creates a new offence of supplying articles for use in immigration crime. The offence has two limbs. Firstly, that the person supplies or offers to supply those articles to another person. And secondly, that when they do so, they know or suspect that the item is going to be used in connection with any offence under sections 24 or 25 of the Immigration Act 1971, respectively illegal entry and assisting unlawful immigration. I would like to ask the Minister about the reasonable excuse elements of this clause. It is a defence for a person charged with this offence to show they had a reasonable excuse. Subsection 3 defines a reasonable excuse as explicitly including that A, their action was for the purposes of carrying out a rescue of a person from danger or serious harm, which seems reasonable, or B, that they were acting on behalf of an organisation which aims to assist asylum seekers and does not charge for its services. This second defence seems to us to create a large loophole in the law. Does the Minister accept that these defences will have the effect of exempting NGOs from criminal charges for helping asylum seekers to cross the Channel? Why would the government seek to do that? The defence categorises organisations which aim to assist asylum seekers between those who do not charge for their services and those that do. Surely this criminal offence is a criminal offence regardless of who is responsible. Why would it be any less criminal if someone does it voluntarily? Why is making money from something the determinant of whether or not it is a crime? As we heard in evidence to the committee, there are charities that can be, I think the word used in the evidence session was mischievous in their activities and how close they come to facilitating illegal crossings to the UK. Does the Minister accept that the activities of some charities can veer close to the line of facilitating illegal entry? And if so, what does the government intend to do about it? The threshold for this defence is a low one. The accused simply needs to provide sufficient evidence to raise an issue, and the contrary is not proved beyond reasonable doubt. Might this be why the Home Office's impact assessment considers that between 4 and 6 prison places, the central estimate is, I believe, 5, will be required per year once this steady state is reached? The Home Office has lauded the new powers and offences in this bill as being key to smashing the criminal smuggling gangs, but it does not appear that the Home Office considers many people will be convicted under these new offences. How can both those things be the case? Clause 14 creates a new criminal offence of handling articles for use in immigration crime. The person has to receive or arrange to receive a relevant article, remove or dispose of the article for the benefit of another person, or assist another person to remove or dispose of a relevant article. Again, Clause 14 provides the same defence to the offence as Clause 13, namely that their action was for the purposes of carrying out a rescue of a person from danger or serious harm, or that they were acting on behalf of an organisation which aims to assist asylum seekers and does not charge for its services. My questions to the Minister about this defence are therefore the same as they were for the defence in Clause 13. Clause 15 provides a definition of relevant article for the purposes of the new offence in Clauses 13 and 14. There are exemptions for food and drink, medicines, clothing, bedding, tents or other temporary shelters, anything to preserve the life of a person in distress at sea, or enable such a person to signal for help. Could the Minister set out for the committee the kinds of articles that she therefore does expect to be captured by the offences in clauses 13 and 14? It would be useful to know what items the Home Office, Border Force and the police specifically wish to disrupt. There is also a power in section 15 for the Secretary of State to amend the list of relevant articles. Could the Minister explain, please, what purpose this power serves? The list of what counts as a relevant article is almost limitless. So does the Minister envisage that this power will be used primarily to create exemptions? The Honourable Member for Perth and Kinrossshire has tabled Amendment 3 to specify that if a person is an asylum seeker, they cannot commit the offence in Clause 13, namely supplying articles for use in immigration crime. It would be good to understand why the Scottish National Party does not think it is possible for asylum seekers to commit this offence. How are law enforcement supposed to know that a person is genuinely an asylum seeker? And even if they are an asylum seeker, what happens if their application is subsequently rejected? The same member has tabled Amendment 4 to require the Commander to include in the annual report information about how they have paid due regard to the Human Rights Act and the European Convention on Action Against Trafficking. Our views on this are the same as my honourable friend, the member for Stockton West, set out on Amendment 1.
Mr. Chair, and apologies for my longer interventions. I'll try and bundle them all into this set of comments. I think in the evidence sessions, one of the most important things that we heard was from Matt Walsh from the Migration Observatory, when he said that demand for cross-channel crossings is essentially inelastic. Even if the price of a crossing doubles, there's still demand for it. People rise to meet that price. And what that tells us is that deterrence alone and disruption alone of the demand will never be enough to actually tackle the horrors that we're seeing in the Channel at the moment. It has also got to be about disrupting the supply of ability to cross the Channel. And that's what I think is really important in this bill, and these clauses go right to the heart of it. So firstly, on the point relative to criminalising all asylum seekers, I did read the submissions that we've had from organisations that I've worked with in the past carefully ahead of the evidence sessions. And I have to say, I found the testimony of the Crown Prosecution Service very convincing on this. They stated very clearly that in addition to these the primary legislation, the CPS will produce guidance that will set out both the public interest threshold and the evidential test that they would seek in order for this to go to a prosecution. And they were very clear with us that the kind of hypothetical examples that the Honourable Member for Perth and Kinrossshire was setting out would not meet that threshold. And also about the point on the amendment about this criminalising all asylum seekers. To try and clarify the point I was trying to make in my intervention, essentially an asylum seeker, during a crossing, anyone can declare themselves an asylum seeker. And that then breaks down into different categories. Someone who is genuinely eligible for asylum in the UK, and when they go through that process will get refugee status. Someone who genuinely is seeking asylum but will not meet the threshold that they want to go through and will not get it. And someone who knows they are ineligible, or may indeed actually be eligible in some counts, but is engaged in the criminal act of facilitating illegal entry into the UK and putting these other people's lives in danger. It is not possible at that moment to distinguish between those people. The asylum process is there to do that. So if you did, if you accepted the premise of the Honourable Gentleman's amendment, it actually is a wrecking amendment. I know it's not intended that way, but it would in reality be a wrecking amendment to any kind of intervention on a crossing at sea. Are you...
There's just one thing he sort of forgets and neglects to mention when he is correctly summarising what's happening with these new members. It's already illegal to arrive into the UK illegally. That's what's happening. That's why so many people have been arrested, who have now been processed and been sent back. It is illegal to come to the UK. And just now, if you've not got any means to support yourself when you're here. So all this bill is doing is finding new ways to criminalise people. And so, like, I don't know what the point of the new clauses are when all of this is already happening.
The Honourable Gentleman for that intervention. It is a really important point he's making, but I don't accept that it's not creating new criminals for all asylum seekers or for all people. It's creating new criminal offences for those engaged in the exploitation of people and the trafficking or smuggling of them across the Channel in great danger, and we cannot allow that to continue if we care about these people's lives at all. The point I would make is that, like, in every single MP in this room's constituency, there will be a cannabis factory where probably an underage Vietnamese child is working cultivating cannabis. And if they've arrived in the last 2 years, they came across on one of those boats. There are significantly serious organised crime networks exploiting the vulnerability of these people in order to facilitate those crossings. And this is how you stop them doing it, and it affects every one of our communities. I just want to make 2 final points. I'm aware I'm testing people's patience. The first one was about the criminalisation of organisations that help asylum seekers. I think this is a really important point, and the distinction has to be clear. I did have concerns about this going in, but the evidence sessions completely reassured me. Again, the testimony from the CPS said they're just asking the weather in Dover when you're in Calais, and those kind of things would not facilitate it. And I think the testimony saying that the National Crime Agency are using this to tackle serious and organised crime makes clear what the purpose of these amendments are. And to the Honourable Lady for Kent's points, Wealdon Kent, sorry, excuse me, it's quite far south for me. Her point about the sector and the point about charging is, I think there are some organisations out there that are charitable, that do this for free, and there are some organisations that put enormous fees and are extremely exploitative, and that's where that distinction comes from. That would be my interpretation of the legislation.
Will you give way?
Yes, I will give way.
Presumably, though, it seems reasonable to think that there could be a third category, which is people who charge fees that aren't exorbitant.
Yes, that's absolutely right. I wouldn't have, in my experience of the Channel Coast and working in the refugee sector, those don't exist. Anyone who was to do that would be probably giving immigration advice, which is a regulated component under UK legislation, and would be structured differently than someone on the coast or on a boat, on a vessel, in the way that this legislation sets that out. I'm happy to be corrected, but that would be my interpretation of it. And then I finally just want to come to the point about mobile phones and the different points that are listed here in terms of what can be seized when a vessel is disrupted. We heard so much evidence last week, and there is so much evidence out there that the crossing of the Channel is the final stage in a very, very long process of criminal gang networks and organised crime networks and just immigration networks that stretch through Europe, through allied countries and into countries it's very difficult for us to have relationships with. And we know that those smuggling networks are all orchestrated by mobile phone. So it's so important that this legislation includes that incorporation. But in the concerns that the honourable gentleman from Kinrossshire is raising about criminalising the most wretched people in the world, when you look at the exemptions that are in this legislation, those are clearly humanitarian. Those are clearly the kind of thing people need to survive on a dangerous sea crossing or on their arrival. The only exception is their phone. And it's because we know that the data taken from those phones is critical in the fight that those are excluded. And that's why I think it's really important that that component remains in the legislation. Thank you.
Sarah?
Thank you, Chair. It's an honour to serve under your chairmanship. I just wanted to just make one particular point. Obviously, these laws, when these particular provisions, when there's going to be supplying of articles or if there's going to be handling of articles, I assume the majority of these will actually be held out of the UK. And I know that obviously Clause 17, which we'll come on to, does try to apply that the offences will stand and have effect if it's outside. But I just wonder how the Minister actually sees this working in practice, because I think the majority of people will be out of the realms of this, and how are we going to be enforcing this in practice? And I guess just the second point I wanted to raise was just in Clause 14 of handling of articles. The Law Society has great concerns that asylum seekers may actually be victim if they are forced to handle any of the goods. So I wonder what the Minister proposes to how to address this point. Thank you.
Thank you very much, Mr. Stewart. And we've had an interesting debate, which has come at what is a very complex problem from quite different angles, if I could put it that way, ranging from the honourable gentleman, the member for Perth and Kinross, giving everyone that gets on those boats the benefit of the doubt, all the way through to perhaps the honourable member for the Weald of Kent, somewhere towards the opposite end of that spectrum, with everything in between. I think the important thing that we need to get right in this bill is that we give those who are trying to prevent these dangerous boat crossings all of the tools that they need, that they tell us they need, to help them deal with the criminal gangs that have been allowed to take hold across the channel and are currently perpetrating this evil trade. I think all of us agree that we want to stop that, and I think all of us agree. I'm trying to start off by Mr. Stewart talking about what we agree on, so that I can then come on to try to explain how I believe the clauses that we're discussing will assist in that. I think we all agree that the right way to go about this is to ensure that the decisions about who will be allowed to come into our country are taken by the authorities in the country rather than by sophisticated internationally organised criminal gangs with supply chains that go across many different jurisdictions and who make millions out of their illegal trade. I just wanted to give the committee a couple of examples that I think might put some flesh on the bones of what we're trying to do with these clauses that we're discussing in this grouping. But before I do that, I just want to emphasise that the idea of these clauses, even though people may think they're wide-ranging, is not to criminalise every asylum seeker or even the vast majority of asylum seekers. It's actually going to be an intelligence-led thing, and it's work that, and powers that the National Crime Agency and those who try to police our borders have told us would assist them in doing the things that they most want to do. And I think that the NCA gave this evidence to us last week to prevent, which is to deter organised immigration crime from participating in it, to pursue, which is to disrupt the way that organised criminals work, to protect, and that is to detect and act before the damage has been done. So not wait until there are deaths in the channel, but try to stop those small boats being launched in the first place, and to prepare to manage and deal with the issues. So I'm just going to read into the record a couple of examples of where these powers, which are short of the Section 25 of the Immigration Act powers, which give powers at the moment, but are short of that power because they're preparatory acts, which is what we're dealing with in these clauses. Just to give honourable and right honourable members an insight into what we're trying to achieve. There are two case studies I want to read into the record from the National Crime Agency. First one is the articles offence, which is handling articles. In November 2024, there was a man called Amanj Hassan Zada, who organised cross-channel small boat crossings from his home in Lancashire. He was jailed for 17 years after being found guilty of people smuggling charges. Following an investigation by the National Crime Agency, investigators were able to link him to 3 separate crossings made from France to the UK in November and December 2023. He was convicted under Section 25. Each crossing involved Kurdish migrants who travelled through Eastern Europe into Germany, Belgium and then France. It's possible that the reasonable suspicion element meant that investigators would have met the requirements to arrest and charge him earlier and ahead of the Section 25 becoming an option if the new offences had been on the record, on the statute book, when this was actually going on. This man was also moving between the UK and Iraq quite regularly, meaning that this would have assisted investigators. For example, he was overseas, but he had access to some of these articles, and when he was in the UK, so he would have been in the scope of the offence. We would have been able to interdict and arrest him earlier and prevent those crossings from happening. So part of the idea of these new offences is that they'll be intelligence-led, but they will be preparatory. They will be attempting to disrupt before the more serious Section 25 offences actually happened. And therefore they will prevent some of the damage that has been done if that actually is allowed to happen, because the authorities don't have enough evidence to arrest him on the more serious offence. Preparatory acts offence is another case study. An investigation into an Albanian organised crime gang using small boats to facilitate illegal immigration to the UK led to the arrest of an individual who was identifying rigid-hulled inflatable boats for sale on behalf of that organised crime gang. It was the gang that subsequently bought and used the identified boats for organised immigration crime purposes. The individual was never directly involved in the movement of migrants or the purchase of those boats. He simply sourced them. The NCA had and provided evidence that they were on the periphery of the organised criminal gang, and they were researching for the gang themselves to support their criminality. Despite this evidence, he was never directly involved in the actual facilitation, so the case couldn't go through to charging. The preparatory acts offence would have enabled prosecution here, as the individual took part in the research and planning of acts to facilitate organised immigration crime, despite not being directly involved with the facilitation and illegal entry of migrants itself. Both the type of information and the circumstances the information was collected under would be captured by the new offence, and the evidence that the NCA had would have been sufficient for a sentence of up to 5 years. So what we're talking about here is actually trying to do prevention work, to disrupt, to interdict, and actually to get to the stage where we can stop some of this stuff happening before it's reached its full maturity and people's lives have actually been put at risk in the channel. So it is a different approach. To sit there and watch and wait until something's happened and people have perhaps died is one way of doing it. But the entire approach of the counter-terrorism style powers, of which the powers in this clause are an example, are what the NCA and other people have asked us to assist them with, because they see the pattern in their information gathering of how these things are organised, what the patterns are, who's involved, how they do their business. And they demonstrate and have demonstrated to me and others that these kinds of powers would be really useful in a preventative way and may very well save lives. So I hope that just giving those two examples will sort of mean that we can have more of a handle on the kind of things that these clauses are trying to do. The Honourable member for Perth and Kinross again was worried that these powers will criminalise absolutely all asylum seekers. That is not the intention of these powers. The intention of these powers is to be completely intelligence-led and focused on perpetrators, whether they're on the periphery or directly involved. And I have to say to him, 95+% of people who arrive illegally that we know of on small boats claim asylum. So his amendments, which would take all people who claim asylum out of consideration of these offences, would be an obvious way of avoiding the offences being brought to bear and could be used by any of the people that are involved in organised immigration crime to avoid the powers being used against them. And therefore, whilst I'm sure it wasn't his intention at all in putting these amendments down, the effect of them is to wreck the approach to prevention and disruption that these powers represent in the bill. I do want to be clear, and I think it's important that I put this on the record, so I'll say it again. It's not the intention to target asylum seekers with these new offences. The offences don't penalise individuals for entering illegally any more than they're penalised already. But they criminalise the conduct of activities connected to facilitation and illegal entry offences through the supply or handling of articles. In practice, focus is going to be intelligence-led and targeted at those who law enforcement believe to be working in connection with organised criminal networks. And believe you me, Mr. Stewart, these networks do exist in the UK. They do come across on small boats themselves. They do travel between the UK and some of the countries of origin they're working with, because we can track some of them and follow some of them, and we know exactly that is what happens. Therefore, it's important that we can bring these powers to bear. We know there are individuals who've claimed asylum in the UK and operated criminal activity from within the UK. I've just given the committee an example. As part of a wider criminal gang with networks overseas in order to facilitate smuggling into the UK. This is a phenomenon we're aware of today, and we can't exclude anyone with an asylum claim, as the Honourable Member would want us to, regardless of the circumstances, from the scope of these new offences. Excluding asylum seekers fuels abuse and exploitation of the asylum system, as well as the intentional frustration of our criminal justice system, with those involved in the supply and handling of articles able to claim asylum on arrival or arrest and therefore evade prosecution. I'm sure that wasn't the Honourable Gentleman's intention, but I hope he will also take at least some comfort from what I've said about this not being this power not being applied to everybody, but being very focused and intelligence-led. So I think we can't provide blanket exemptions, and so therefore I hope, given the explanation, he'll withdraw those amendments when we come to the vote. Turning more broadly to what these clauses will achieve in practice, Clause 13 creates a new offence of supplying or offering to supply an article where the individual knows or suspects that the article is to be used in relation to an offence under Section 24, which is illegal entry, or Section 25, facilitation of unlawful immigration in the Immigration Act 1971. We know that criminal smuggling gangs are using wide international and transnational networks to supply items for their criminal ventures. This new offence is intended to allow law enforcement to target those who act in a way which removes themselves directly from the act of people smuggling, but allow them to be caught under, which would allow them to be caught under existing legislation, and allows an earlier intervention, like the example I've just used, potentially before boats have even been launched and lives have been risked. That's the prevention side. Clause 14 creates a new offence of handling items where the individual knows or suspects that these articles have been, are being or will be used in relation to an offence under Section 24, illegal entry, or Section 25, facilitating unlawful immigration entry under the 1971 Immigration Act. Those that have that knowledge or suspicion and who receive or arrange to receive a relevant article, remove or dispose of a relevant article for the benefit of another, or assist another person to remove or dispose of a relevant article would be caught. These clauses include important safeguards, and some of them have been mentioned in the debate that we've been having on this group. This includes, but is not limited to, their actions being for the purpose of carrying out rescue of a person from danger or serious harm, or that they were acting on behalf of an organisation that aims to assist asylum seekers and does not charge for its services. These new offences will allow for earlier intervention by law enforcement who, using intelligence-led methods, will be able to target individuals who are a number of stages removed from people smuggling to be caught under existing legislation. These clauses enable law enforcement to act earlier and faster in tackling immigration crime and the wider criminal network involved in supporting this trade. The maximum sentence, as it was pointed out by some colleagues in the debate, for these offences is 14 years imprisonment. Clause 15 defines what articles are not in scope for Clause 13 and 14 purposes. Supplying and handling articles for use in immigration crime. It specifies that relevant articles include anything or substance that does not fall into the excluded items. This clause is deliberately wide in scope to ensure law enforcement can stay ahead of the rapidly changing modus operandi of these criminal people and people smuggling gangs. Clause 13 and Clause 14 rely on a test of what an individual supplying or handling items knew or suspected at the time of their actions, ensuring that while these are broad categories of items, those acting legally and in good faith will not be caught by these offences. I think also various colleagues have referred to the evidence that the Crown Prosecution Service gave on the guidance and codes that will be attached to these, and also the public interest test, which provides further protection to ensure that people who were innocently trying to assist are not caught up in these offences. So this clause contains that carve-out of what articles will be considered relevant articles for the offences, will not be considered relevant articles for the offences in Clause 13 and 14, including food, medication, safety equipment such as proper life jackets, because as we know, many of those who get into the boats are given fake life jackets that actually sink and don't keep anything afloat. The clause also gives the Secretary of State the power to amend the list of carved out items by regulations, but only to add items to the carve out. The Honourable Lady, the member for the Weald of Kent, was talking about that in her contribution. Whilst this is a Henry VIII power, which we all, none of us like particularly to see, it's a power to add, it's a power to allow the amendment of excluded items, and it can only be used to add items we wish to carve out from the offence, not to take them away. So the Henry VIII power could not be used by some subsequent minister, not me, who would want to take food or medication out of that list, for example. You can only add things to the list rather than take things out of the list. And then the idea of that is to ensure that the offence can be kept up to date if trends change and different things start to be used. So that would enable a safety a thing to be added but not taken away. Any regulations would be subject to the affirmative process and undergo scrutiny by each house before the regulations can be made and the list amended. I hope that gives her some reassurance about the questions that she asked, and with that I beg to move.
Pete Wishart.
I wish I could say I was reassured by the Minister and her response. There's things she said which encouraged me, and which I think she was very genuine and sincere about. And I think she's right, and I think everybody who's contributed today and all the people we've heard from in the course of the past couple of weeks don't want to arrest asylum seekers. I think that's the last thing they really want to do. And I accept that that's the case in practically everything that anybody says about these things. The thing is, more are going to be arrested because of these clauses. More of them are going to be facing the justice and whatever way it applies right across the United Kingdom because of these new offences. And what we've forgot is it's already illegal to enter the UK irregularly. And I think I've got a number here which is 6,477 people were arrested in 2020 because of arriving in the UK irregularly. What we're doing with these new clauses isn't addressing the illegality of issues such as people coming to the United Kingdom. It's finding new ways of ensuring that they're going to be subject to court proceedings, to being on the wrong side of UK law. And I think that is the thing that concerns us most. Now, I know a lot of people have referred to a number of the agencies that gave us support today, and I listened to the NCA's evidence, and there was some of it that was very interesting and compelling, and I accepted that they are wanting to target particularly the gang members and those that are involved in this vile trade. And that's what we should be helping them to do. And obviously, asylum seekers are going to get caught up in all that, but it's going to be down to them. And this is why, when we're doing these sort of new ways to try and find ways to criminalise people who are coming to the UK, let's allow them the ability to focus exclusively on trying to apprehend and secure justice when it comes to that. Yes, of course.
I thank the honourable gentleman for giving way, but will you not take my word that the offences are going to be very intelligence-led? So they're not targeting all asylum seekers, but they certainly would target someone who was coming over on a boat who may claim asylum, who's been involved in an organised immigration gang and has been organising the supplies, for example.
I do accept that, and I obviously accept the Minister's word when it comes to all this, but what we need to see is things which are in the bill, and the things that we see which we don't like, we don't think are actually going to help us just in what the major objective is, which was disrupting the gang's business model and ensuring that they're brought to justice. It just does not happen with these new clauses. Mr. Stewart, this particular amendment doesn't offend me the same one as the next one which I have, so I will, with leave of you, withdraw that, but I will reserve the right to push the vote for the next amendment which I'll present. Thank you.
Thank you. So I take that you're referring to Amendment 4, I take it, in terms of the would. Okay. Is everyone content for the Amendment 3, to be withdrawn?
Aye.
Aye. Clause 13 has already been debated. The question is that Clause 13 stand part of the bill. As many as are of that opinion say aye.
Aye.
Or the contrary, no. I think the ayes have it. So, Amendment 4 proposed to Clause 14 as on the amendment paper. The question is that the amendment be made. As many are of that opinion, say aye. Or the contrary?
No.
No. No. I think the noes have it. The noes have it. Clause 14 and Clause 15 have already been debated. With the leave of the committee, I'll put a single question on those clauses. The question is that clauses 14 and 15 stand part of the bill. As many are of that opinion, say aye. Aye. Or the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that Clause 16 stand part of the bill. Minister.
Thank you very much, Mr. Stewart. The provisions in Clause 16 create an additional tool to act earlier to disrupt criminal gangs smuggling people into the UK. The new offence targets specified preparatory activities associated with people smuggling. These activities relate to the collection, recording and possession, viewing or accessing of information which is likely to be useful to a person organising or preparing for a journey of more than one person into the UK, where their entry or arrival constitutes an offence under Section 24 of the Immigration Act 1971. These specified activities must also be included in conducted in circumstances giving rise to reasonable suspicion that the information being collected, recorded, possessed, viewed or accessed will be used in organising or preparing for such a journey. This clause is levelled strongly against people smuggling gangs and their associates. The clause includes a defence of undertaking these specified activities for their own journey only. Also included as a defence is a non-exhaustive list of reasonable excuses, where one express excuse is conducting these activities to carry out or prepare to carry out the rescue of a person from danger or serious harm. The maximum sentence for this offence is 5 years imprisonment.
Katie Lane.
Thank you, Mr. Stewart. Clause 16, as the Minister has just laid out, creates a new offence of collecting information for use in immigration crime. A person commits such an offence if they collect or make a record of information of a kind likely to be useful to a person organising or preparing a channel crossing, if they possess a document or record containing information of that kind, or the person views or otherwise accesses by means of the internet a document or record containing information of that kind. This is an extremely wide set of information that is being criminalised. We understand the desire to keep these offences broad in order to capture as many offenders as possible, and we support that aim. But if the definition is too wide, there is a risk it becomes meaningless and therefore self-defeating. So it is important to understand how the Minister believes law enforcement will assess whether the information is of a kind likely to be useful to a person organising or preparing for a relevant journey. Could the Minister please explain how this test will be met in practice? It would also be helpful, please, for similar reasons, to know when the CPS will publish its guidance for what might meet the threshold for an offence to be committed under this section. And finally, it is again a defence here for an organisation which aims to assist asylum seekers if it does not charge for its services. So we have the same questions and concerns about this defence as we did in the preceding clauses.
Yes,
Mr. Stewart. I'll quickly talk about this clause. It's one of my favourites in the bill. Having worked in a counter-terror role in the past, one of the most effective ways of preventing terror attacks on the streets of the United Kingdom is through identifying hostile reconnaissance, whether it's physical or online. And that's why I'm so happy to see this in the bill, because it gives our authorities that opportunity to get to these vile criminals before they take to the seas.
Thank you very much, Mr. Stewart. I take my honourable friend's point. This is very much about being able to capture preparatory work for the effort to evade our immigration laws and bring people over in small boats illegally, putting their lives at risk and potentially costing lives for money. And this is about a wide range of potential research, but there are also explicit safeguards in the clause which are sufficient to protect individual migrants and refugees or families of refugees trying to help family members flee danger or serious harm. The defence that a person is conducting these activities exclusively in preparation for their own journey protects individuals from falling foul of this law. This is explicitly focused and aimed at the work that is done by gang-affiliated facilitators of immigration offences. The express reasonable excuse of carrying out or preparing to carry out a rescue of a person from danger or serious harm may, depending on the circumstances, protect the families of refugees wanting to help their loved ones flee. There's also an express reasonable excuse for a person acting on behalf of an organisation which aims to assist asylum seekers and which does not charge for its services. The list of reasonable excuses on the face of the bill is not an exhaustive one. So it's very much a question of having a look at the information that is being gathered and making a judgment, knowing that the idea of this offence is to focus specifically on organised immigration criminality, not on the individuals that may be asylum seekers or may be being trafficked. The gangs organising these journeys don't care about the safety and well-being of the people they're smuggling to the UK. They only care about profiting from this trade. So given the threat to life and bodily harm that these perilous journeys into the UK present to migrants, tragically including children, it's not appropriate to provide an explicit, reasonable excuse that can be relied on by someone putting their child or anyone's child in that kind of danger. Practically, there are questions of operational benefit and public interest, and it's not the aim of this clause to be used to further penalise migrants, as I've said in the earlier debate, who come to the UK illegally with their children on such journeys. So those who are worried that just by the mere fact of getting into a boat, one would fall foul of this clause are wrong. This is focused particularly on the activities of those that are gang affiliated with organised immigration gangs who are seeking to profit. And with that reassurance, I hope that colleagues will be happy to add the clause to the bill.
The question is that clause 16 stand part of the bill. As many other are of the opinion of that opinion, say aye. Aye. On the contrary, no. I think the ayes have it. We now come to the question that clause 17 stand part of the bill. Minister.
Thank you very much, Mr. Stewart. Clause 17 provides for the offences set out in clause 13 and 14. That is the supply and handling of articles for immigration crime, and clause 16, collecting information for immigration crime, to apply to activities committed both inside and outside of the UK, regardless of the nationality of the person by whom they are done. The activities criminalised by these offences are often carried out overseas as well as in the UK by perpetrators of various nationalities to facilitate people smuggling to the UK. This clause will strengthen the offences, enhancing the ability to disrupt those involved in this trade, indiscriminate of their nationality and the location of their crime. Clause 17 also makes provision for where an offence under clause 13, 14 or 16 is committed outside of the UK, so that proceedings may be taken in the UK. For application in Scotland, this clause provides that those proceedings to be made in accordance with the relevant processes and bodies of the devolved administration. Finally, this clause provides that Section 3 of the Territorial Waters Jurisdiction Act 1878, which requires consent from the Secretary of State for certain prosecutions of non-UK nationals on territorial waters, does not apply. In doing so, the impact of these offences are not narrowed, and law enforcement are able to pursue perpetrators of these offences where committed on territorial waters.
Thank you, Mr. Stewart. Clause 17 sets out that the offences of supplying articles for use in immigration crime, handling articles for use in immigration crime, and collecting information for use in immigration crime, so the clauses we've just been discussing, apply to things done both inside or outside of the United Kingdom, regardless of the nationality of the person by whom they are done. In essence, Clause 17 makes these three new offences extraterritorial. Subsection 2 provides that where the offence has taken place outside the United Kingdom, proceedings may be taken in the United Kingdom. When hearing evidence from the Head of International at the Crown Prosecution Service and the National CPS, Sarah Dineley, she said of this provision and subsection 7 of Clause 18, which extends the offence of endangering lives at sea to acts committed outside the UK, that it would create challenges. As she said, we can obtain intelligence and evidence from our overseas counterparts at both judicial and law enforcement level, and the CPS has a network of liaison prosecutors based across the world. We can issue international letters of request, which require the recipient country to execute the action or to provide the information that we have asked for. But for these new offences to work, there has to be dual criminality, which is to say there has to be the equivalent offence in the country that we're making the request to, and there are some gaps across Europe in establishing dual criminality for all the immigration offences that we currently have on our books. Can the Minister then please reassure the committee that equivalent offences to those in clauses 13, 14 and 16 exist internationally in relevant partner countries, so that we can be assured that the extraterritorial scope of the offences will be effective in tackling organised immigration crime? Could she name those offences or perhaps subsequently share a list? We fully support the aims of the government here, but are just keen to establish the efficacy of these measures in disrupting the vile work of people smuggling gangs.
And thank you very much, Mr. Stewart. I thank the Honourable Lady for her observations. I think in practice this does allow for prosecution where an offence was committed overseas. And it may well rely on evidence sharing for international partners. She is right to talk about the network of CPS prosecutors across other jurisdictions. I have to say that in the time that I've been in the Home Office, we have been strengthening these ties and growing them further. And I think that a lot of the work we've done via arrangements like the agreement we came to with the Italians, the German agreement, the work that we've done with the Calais group, the information that we're sharing in and around with the Balkan countries about the routes that go through their countries, the work that the Home Secretary and the Border Security Commander have done, not only in Italy but also in Iraq and the Kurdish region, also out in Tunisia and some of the other countries that tend to be transit. More and more we're focusing on how we can cooperate operationally. Some of this does involve cross-country and cross-jurisdiction work to hit a particular organised immigration crime across the piece on a set day, and there have been some very good examples of days of action that have been cross-jurisdictional. So I think that the muscles in this area are actually strengthening and being worked more. And so I think that this is an added power that will make it easier for us to continue that work. But I'd also just... I will, yes.
I thank the Minister. Thank you, Chair. I thank the Minister for giving way. And I wanted to draw attention to what Sarah Dinley, the Head of International at the Crown Prosecution Service, said in her testimony. And I quote, "I will start with how we rebuild relations with key allies," which implies that relations have been strained with key allies and needed rebuilding. I have talked about our network of liaison prosecutors, and then Sarah Dinley goes into talking about how there's regular engagement, and that engagement events with overseas prosecutors have increased in recent months. Would the Minister agree with me that one of the reasons why we have seen an asylum backlog in recent years and our asylum system has been described as a disaster, a meltdown, and worse in oral testimonies, perhaps because we did strain our relations with key allies?
Yes, when things are cross-jurisdictional and cross-country, one has to be able to cooperate with other jurisdictions with some respect for their particular prosecutorial approaches to things, to be able to share information, to be able to work together operationally and diplomatically in order to try to deal with the significant challenges that organised immigration crime present us with, and the government certainly wanting to renew and strengthen its approach in this area, and I think it's made a good start. I was about to say, Mr. Stewart, that actually people shouldn't underestimate how much how often people who break this law and would fall foul of this increase in jurisdiction actually come to visit the UK. And so it's actually also possible that we could pick them up and charge them here, and actually in some instances be following them and waiting for them when they arrive. And so the extension of jurisdiction, which is at the essence of clause 17, will provide us once more with what we hope will be an extremely effective new tool, which will help us disrupt and begin to dismantle some of the organised immigration criminal gangs.
The question is that clause 17 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it.
I beg to move that further consideration of the bill be now adjourned.
The question is that further consideration of the bill be now adjourned. As many are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it.